I now call the first case. That is case number 114937, the estate of Marilyn K. Parsons v. the Trust Company of Kansas.
May it please the court, respected counsel. I am Mike Crow, representing the estate of Marilyn K. Parsons, the petitioner on the petition for review and the appellee before the Court of Appeals. We would like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Mrs. Parsons passed away subsequent to the trial of this action. First, this is a negligence case, and this court has been steadfast in its decisions that in negligence cases, negligence and causation are fact questions for the trier of fact to determine. Again, this case concerns negligent verdict in Leavenworth County District Court, where the jury unanimously found the Trust Company of Kansas, TCK, negligently failed to train John King as its trust officer, and that there was a causal connection with that negligent training and Mrs. Parsons' damages. The facts, as determined by the jury, showed that better training would have prevented the harm to her. This is not a comparative fault case. During the trial itself, there were very few objections to testimony or exhibits, and there were a lot of exhibits. The jury, in its verdict, only found 1/2 of Mrs. Parsons' actual damages were caused by TCK's negligent training of its trust officer, John King. At the time that the Trust Company of Kansas hired John King, he was practicing law in Lawrence. He represented himself at trial. Therefore, he was in front of the jury a lot. Just for argument's sake, I would note that John King was a defendant, and the trial judge was the Honorable David King. So I don't want to mix the two up. There were no objections to any of the Judge King's jury instructions. At the close of the evidence presented by Mrs. Parsons, TCK made a generic motion for judgment as a matter of law, but there was no argument presented at that time concerning negligent training.
Counsel, can I just stop you there and ask my really basic question for this case? Is there really such a thing as a claim of negligent training or negligent supervision? Or is there just a negligence claim which can be proved up in any numerable ways?
It is just a negligence claim.
But okay, so that gets to the heart of, I guess, my question with this case is that it doesn't appear that either the parties or the district court treated this like a claim, like a regular negligence claim. For example, I don't think there are any negligence elements instructions.
The judge,
is that right?
Well, the way Judge King put it is that this is a negligence case with a special finding that the causation the causal connection was that
I guess that's what I'm wondering. Is that correct as a matter of law? Is
we believe it is. We believe the judge gave the proper instruction because it was contained in the instruction itself. It was not a comparative fault case, so there wasn't anything in that regard. But negligence was defined within the instructions themselves on negligent training.
on negligent training and then on negligent supervision? I mean, the reason
Yes.
that's a problem, potentially at least, is that the Court of Appeals drew a line between those two and said the evidence didn't support the verdict that the jury actually reached on negligent training.
The Court of Appeals decision, our understanding, is that it was based on their determination that the facts did not demonstrate a causal connection between the negligent training and her damages. Now, I would point out that the jury only awarded 1/2 of her claim damages. And the damage was pretty much liquidated. I mean, it was what it was, but they didn't assess it all to negligent training. I mean, we thought we proved it, but they didn't assess it at that. But we believe the jury, I mean, there was no confusion on the part of the jury in that regard, that negligent training, the causation part, the harm, whether it caused harm, is the definition in and of itself for negligence. But you're absolutely correct. This is a negligence case.
Well, so I'll just ask the one more question I have. Is our job on review, on appellate review, to determine whether or not there's any evidence that a reasonable juror could have found supported a negligence claim? Or are we more cabined in to look at whether it would support a negligent training claim, if such a claim exists?
Okay, either one. I guess I apologize, but I mean, we think it was negligent training. The judge, the initial instruction was negligent supervision and training, and listed almost all of those elements that the judge listed were concerning training. But Judge King decided that actually there are two different types of proof for negligent training and negligent supervision. Because negligent training, the only issue on causation is, did that cause the harm? So I don't know. I guess we have no preference. I think that's a good point, and I'll be candid with you. I hadn't thought about it.
Counsel, if I could follow up on Justice Stiegel's questions. I'm looking at the jury instructions, and I think it was established just a minute ago that there was no standard elements instruction for negligence.
Right.
Is that right?
Right. That's correct, Your Honor.
And so I'm looking at the specific instructions, instruction number 18 and instruction number 25, and I can't find anything in there that says the jury needs to find that the defendant in this case had a duty to train, which would be a primary threshold question for any kind of negligence claim, would it not?
The claim in that instruction was that they failed in their duty
Well,
to instruct.
I'm looking at 18, and there is the allegation that there's a failure to train, and it must be proven by a preponderance of the evidence. And then in the next instruction, 25, it says a claim based on negligent training depends upon establishing facts showing that more or better training would have prevented the harm.
Okay.
But I can't find anything here that says there was a duty on the part of the defendant to train.
I believe there was. There
Now,
were,
and the reason I say that, I contrast that with the earlier part of that instruction 25, in which on the supervision issue, it says an employer has a duty to supervise an employee. But there's nothing that I can find that says the employer has a duty to train. So if you can find that in the record for me
Okay.
at some point, I'd appreciate it.
Okay,
All right, thank you. Assuming I am correct, what is that duty or case?
Well, no one objected to the instructions. So it'd be, have to be clear showing of injustice. The standard, I don't have it in front of me right now.
Well, if the instructions were erroneous, that wouldn't be judgment as a matter of law, would it?
No.
It would be a new trial.
No, it would be well, yes. The Court of Appeals did not, the only issue that they decided on, they jumped over the preliminary issues of whether there are objections to the instructions, things like that, and just found on there was no causation.
Are these
Yes.
sorry, go ahead.
Well, as I understand the record, not only was there no objection, but once Judge King kind of laid out why he worded this instruction the way he did, the defendant actually said, okay, I understand, almost an acquiescence.
Right.
I don't know whether or not that goes so far as to invite the error, but it seems to be more than just a failure to object, at least. Is
Yes.
that?
And we did, and the plaintiff did not object either, I want to emphasize. And we believed, and continue to believe, that Judge King was correct on the law.
And just to be clear then, so you would see training as distinct from supervision, or as a subset of the duty to supervise includes the duty to train? What was your theory on that?
Well, Judge King, initially, we thought we put the two together. The negligent supervision and training were tied together.
Judge King explained why he separated
Yes.
them, and so at this point, do you agree with his separation, or do you still feel like it should be part of the duty to training should be part of the duty to supervise?
I got to tell you, I agree with his. He convinced me. I certainly may be wrong, but at least as far as what the case within the case, we believe that was correct, that he was correct.
Counsel, you're out of time. I'm going to ask if
Okay.
we have any, no, I'm going to ask if we have any more questions
Sure.
at this time. And did you need 30 seconds to sum up, or do you want to wait till rebuttal?
Well, I could wait to rebuttal other than, I would just, I'll wait to rebuttal. And to be fair, I don't want to take more of my time.
All right, thank you, counsel.
May it please the court, Rachel Wetta on behalf of the Trust Company of Kansas. As kind of a background to this case went to trial in June of 2015, and on the night before the case was submitted to the jury, the court held the held the conference on defendant's motion for judgment as a matter of law. And at the end of that motion for judgment as a matter of law, the judge outlined the claims that the plaintiff still had, which were breach of contract, breach of fiduciary duties, negligent representation, and negligent supervision. There was no mention at that time of negligent training because up to that point in the case, negligent training had not been a cause of action in the case. Going back to Justice Stiegel's question about whether or not negligent training and negligent supervision are separate and distinct causes of action from simply negligence. In this case, we have treated them as separate and distinct causes of action based on the case Estate of Belden, which is a Kansas Court of Appeals case. And in that case, the Court of Appeals said that negligent training differs from negligent supervision in that negligent training requires the plaintiff to prove that there was some additional training that the defendant could have presented that would have made a difference in the case, that would have changed the defendant's conduct.
Is that just in my reading of this case, it seems to me that I would agree if you're saying the way this case was handled arose out of some Court of Appeals case law.
Correct.
My question is whether or not that case law, and Belden in particular, confused the difference between how you prove a negligence claim and whether there are distinct causes of action.
I don't know that there are necessarily distinct causes of action, but I think because this case was presented to the jury with distinct causes of action in our jury instructions as opposed to a standard negligence instruction. We are kind of stuck looking at it that way at this
Yeah,
point.
we are somewhat stuck, but another thing we're stuck with, it
Yes.
seems to me, is that the jury did find negligence.
They did.
And the
indeed.
jury, I mean, we can presume, found negligence and found a causal connection and found damages against your client.
Sure. But they
And
did. Okay.
if we're just dealing with a negligence claim, how do we overcome? How do you overcome on behalf of your client that jury verdict, even though it did seem to come through a set of instructions that treated these as separate claims?
So as Justice Nuss pointed out, the instruction for failure to train didn't include an element where the jury was supposed to find that we had a duty to train him in some way, shape, or form. I know you guys have all had the opportunity to look at our briefing. The whole claim for negligent training is based upon an internal policy for the Trust Company of Kansas that says our trust officers are not supposed to engage in the private practice of law. And that is the entire basis of the failure to train claim. And at no point did any witness come forward and say that we had a duty to train John King on this policy, nor did the plaintiff present any law that we had a duty to train on this policy. In fact, the uncontroverted evidence is that the policy was internal facing only. The policy was in place so that TCK could have the full-time best efforts of their employees. So looking at that policy, it's a matter of, did this create a duty to Marilyn K. Parsons? And we believe that it did not.
Isn't this a condition of employment?
That he not engage in the private
Yeah,
practice
I mean,
of
you
law?
guys don't want him out practicing law because you're going to get tagged for it.
Correct.
And so how would you not have an obligation to tell him that?
I believe we had an obligation to ourselves to tell him that, but it's a matter of, did we have an obligation to Marilyn K. Parsons? What's the purpose of the policy? The policy was to protect TCK, not necessarily to protect the clients of TCK.
You didn't care about your clients getting abused. You only cared about getting tagged for the misconduct of your employees.
I don't believe that that's true on behalf of TCK, but I do believe that the evidence that came in at trial was such that the policy was not in place for the benefit of our clients. The policy was in place for our benefit.
Let me ask you this, and I've been trying to listen to you guys at the same time, do some legal research. It's not working very well, so I'll just ask you. So based on what you said, the training issue showed up sort of all of a sudden at the jury instruction conference. In preparing your proposed instructions on the supervision claim, which is, I mean, we're all kind of used to those claims if we do defense work. Did PIC help you out? I'm trying to figure out what PIC says about negligent supervision.
We did not include a PIC instruction for negligent supervision because I don't believe there is one.
Yeah, okay.
We actually did not, in the defendant's proposed jury instructions, we didn't include any instruction on negligence. I don't believe. We included instructions on duty to control employees and things like that.
Is it fair to say it just showed up then? Because there had been, in the pretrial, hadn't there been mention of allegations of a failure to train? Just not as a separate theory, separated from supervision. Am I correct with that?
You are correct that there was an allegation of failure to train as a part of the breach of fiduciary duties claim. And that was in plaintiff's proposed jury instructions, and then they submitted a proposed verdict form that included in their negligent supervision claim, it said negligent training and supervision, but it wasn't in their jury instructions in that form. And it wasn't in their proposed pretrial order, amended pretrial order, or supplemental amended pretrial order. So it was never a separate and distinct cause of action. In our mind, it was a portion of their breach of fiduciary duties claim against the Trust Company of Kansas.
Can you address the issue that was raised when we were asking questions of opposing counsel, and that is, there's nothing in the jury instructions that I can find out that says, jury, in order for the plaintiff to prevail, you must find that there was a duty of training.
That's correct.
Can you-
I don't
can you-
believe that was in there.
And so we now have a verdict of negligence by a jury in which were not asked to find one of the critical elements to find negligence.
Correct.
And to go back to Justice Lukert's question, as I recall reading the record at the jury instruction conference, Judge King proposed this, and both parties, counsel for both parties, at the bottom line basically said, that's fine with us.
Correct.
Where does that leave us?
That leaves us with a clear error standard of review. And in this case, that means, so the standard of review is, was the instruction legally and factually appropriate? And if not, is the court of the opinion that the giving of the instruction or lack of giving of the instruction clearly influenced the jury's verdict? Would the verdict have been different but for this instruction? Obviously, without the duty element of the instruction, that's a legal error. We also believe that it was factual error to give the instruction to begin with because there's no evidence in this case of any causation between any lack of training and John King's conduct. Finally, we won on every claim that the plaintiff presented except for this one. So if this instruction had not been given, we believe it's clear that the verdict would have been different, would have been a complete defense verdict.
Couldn't you equally assume that the jury found negligence and they would have just put it under whatever category they found that said negligence?
I don't
i.e.
believe...
negligent supervision versus
Sure.
training.
So if you look at the verdict form, which plaintiff submitted with his brief, the jury did consider negligent supervision as well, and on that claim, they were split 10-2. So I don't believe it's true that they were just looking for some place to put a verdict against TCK. They were considering the actual claims presented to them and considering each one individually. They were split on negligent supervision, but they were unanimous on negligent training. So I don't think that we can extrapolate from what the jury did that if we removed negligent training, they would have just gone back to negligent supervision.
And do you agree with my reading of the Court of Appeals decision that the reason the Court of Appeals found there was no evidence of causation was based, at least some, on some of the evidence that Mr. King was ignoring or not reading the policies anyway, so what would it matter? Did I read that correctly?
I think that you did read that correctly. The only evidence plaintiff has ever been able to point to suggest that training on this policy would have made a difference is that John King said, I never received a copy of this policy. But in addition to saying that, he also said, I suppose I could have pulled it up on the internet, but I didn't do that. If they had handed me a physical copy of this policy, I probably wouldn't have looked at it anyway. I've worked in trust companies before. I've seen these policy and procedure manuals before, and I don't usually read them. I acknowledge that by signing this, I'm saying that I have received and read this policy, but I didn't do that. What the Court of Appeals did not get into is there's a whole lot of other evidence that nothing about this case would have changed because John King and Marilyn K. Parsons had a pre-existing relationship. Before John King came to TCK, he was working at a different trust company and he was serving as her trust officer and he was also serving as her
It's kind of a bad faith argument. It's like this was a bad guy and
Yes.
it doesn't matter how much good training he would have gotten. He would have acted badly anyway.
Correct. In fact, I think the most telling evidence of that from this case is that once John King was fired from TCK, we helped him clean out his office. We found this letterhead that said the law office of John King, and we started to investigate with Marilyn K. Parsons what was going on. Shortly, a couple months after he left his employment with TCK, Marilyn K. Parsons came back to TCK and said, John King accessed my non-TCK private bank account and withdrew funds. And so we went and helped her go through her bank records. We determined that he had taken quite a substantial amount of money from her. And at that point, we made a complaint of suspected elder abuse and we turned him in to the Kansas disciplinary administrator. there was an investigation. He eventually lost his law license, and through all of that, both John King and Marilyn K. Parsons continued their attorney-client relationship. After she knew he was accessing his bank accounts, after he knew he had been turned in and was at risk of losing his law license, they both continued this attorney-client relationship. So I think what the Court of Appeals was looking at is, through all of the evidence presented at trial, there's a single statement that says, no, I never received this policy manual. Is that sufficient in this type of case to say a reasonable jury could have found in his favor that receiving that procedure manual would have changed something?
Why was this not invited error, given the statements that counsel made after Judge King made his explanation at the instructions conference?
I haven't read all of the invited error case law, but the cases that I have read are usually cases in which the attorney actually submitted those instructions as a portion of their requested instructions. In this case, I can't speak for what my colleague was thinking when he said, okay, Your Honor, that's fine. I believe what he was saying was, I understand your reasoning and I'm not going to object. I don't know if that rises to the level of invited error when a jury instruction is as erroneous as this one. I don't know if I can answer your question any better than that. I apologize.
No, that's probably a good answer.
Okay.
Because you're right. Usually it is a situation where they submit it, but it's hard to tell from this of whether or not the attorney is saying, okay, yes, you're right. That is the right thing to do. Go ahead and do it. Or just saying, no, I just don't object. So
Yes, I agree. It's hard.
Ambiguity.
Yes, it's hard to, from the record on its face, to know. I have the benefit of knowing the attorney, so I probably know better what his intentions were, but I don't think that comes through in the record. I think at the end of the day, from our perspective, this case comes down to Marilyn K. Parsons never intended to plead a cause of action for negligent failure to train. She didn't prove a cause of action for negligent failure to train, and the jury got this one wrong, as did the court when we filed our motion for judgment notwithstanding the verdict.
On that point, if those things that you say, the first things that you say are right, why wouldn't the remedy be for a new trial? Because arguably, if the district court erred by delivering the negligent failure to train instruction, I mean, arguably that hurt the plaintiff. As you just said, they didn't intend to plead that cause of action, and they didn't intend to prove it up. Why shouldn't they get a new trial as opposed to just judgment against them?
Sure. We actually, in our briefing, we did argue alternatively for a new trial, but I do believe judgment as a matter of law in this case is the more appropriate remedy, because we do have all of the evidence from the trial and there is no evidence that would support this claim. So while the appropriate remedy may usually be a new trial, I think in this case, when we have all of this evidence in front of us, the more correct response would be to just enter judgment in our favor, because there's just simply no evidence that the plaintiff has ever been able to point to through the district court, the Court of Appeals, or here, that any training, even any hypothetical training, would have made a difference. There are a couple of training elements that they tried to put forward in their brief, like the $5,000 rule and the Kansas administrative regulations, but those were dismissed by the district court and the jury. Are there any other questions that I can answer?
Any more questions? Thank you, counsel.
Thank you.
May it please the court. Just very quickly, I've taken a look at the negligent supervision and training instruction 25, and it is entitled negligent supervision and training, and I believe that it sufficiently informs the jury of both negligent supervision and training, but the court in the verdict form split it off because of the different standards, but that duty is still there. I do not believe that the jury would have been confused by that, and certainly counsel at the time of the conference on instructions was not confused. And there was, everyone agreed that the court was given the proper instruction. Now, I want to point out that this was just not about the policy book that John King never received. And to clarify things, first off, there were three types. One was 2000, which is the one was in effect when he was hired, and one in 2010. And he never got the 2000, but he did sign a receipt for the 2010. So I think a reasonable jury could have reduced the damages by the amount that was misused until he was discharged in 2011. Second, the court instructed that they should have, they failed to train and orient John King that he was prohibited from practicing law, failing to provide training regarding the company policies, and failing to provide training regarding fiduciary duties. And on the fiduciary duties, I want to point out that there was this $5,000 rule that Robert Kirkland, the expert for the plaintiff, testified to, and that was when a trust officer directs the trust company to transfer funds from one of their customers' accounts in excess of $5,000. The reasons have to be stated specifically, and the trust company has a duty then to investigate and, if necessary, call the customer. And that did not happen. And some of the stuff that was listed as the reasons by John King, these are not Marilyn K. Parsons making these instructions. It's John King.
Counsel, what about the argument that no amount of training would have prevented this because Mr. King was a bad actor?
And that was before the jury. And I got to tell you, I'm not here to defend John King, but he represented himself. He was upfront about things and was very impressive. The evidence showed that he's a triathlon, Ironman contestant, all this kind of stuff. He came across, the jury believed him. The jury, it was to our detriment because we had a fraud claim against him. And the jury did not find fraud, did not find any punitive damages. The jury believed him. That's all.
So
I can
your
say.
argument is that the jury was presented with evidence that he was such a bad actor that no amount of training would have changed his bad behavior.
That was the position of TCK, yes. And the jury just didn't buy it all the way. Now, they did reduce the damages by 1/2, and I think probably they reduced it, like I said, about after 2010. I think they probably reduced it by anything below, any transfers below the $5,000 mark, and anything that they determined was for attorney fees, legitimate attorney fees, which quite frankly was not very much. The guy was amenable to training. They paid for him to go to CLE on ethics, of course, required ethics. And the presenter said, you need a written contract for your attorney fees. So he put together a written contract that was 5 or 6 pages long that, was totally unethical. Said even if he didn't do anything, she was supposed to pay him $5,000 a month. But obviously he obeyed the training, but unfortunately he didn't do the ethical thing in that regard. But he did follow, he was amenable to training in that regard. Marilyn K. Parsons denied that she signed those contracts, and that was a question of fact. But, you know, he was upfront about things. He didn't blame TCK for everything. He said many a time, I wish this hadn't happened. You know, if I'd known, it wouldn't have happened.
Counsel, you're out
That's
of
it.
time. Do you need 30 seconds to wrap up, or do you think you've made your points?
So I believe we have made our points, but we believe that, and I know you're focusing on those instructions. We believe the instructions were not confusing the jury. They properly presented that TCK had a duty to supervise and train Mr. King, and that had to be adequate training, and that by failing to adequately train, that caused 1/2 of Mrs. Parsons' damages.
Counsel, I need to ask you.
Yes, sir.
Would it be Mr. Kirkland's testimony as your expert that would show the breach of the duty to train,
Yes,
and that and that offered an opinion that in fact the defendant had breached that duty? So
That was his
those
opinion.
silver bullet questions
Yes.
are going to be in your examination of him.
and he's a lawyer too, and specializes in this, so he knows what needs to be said. I'm not so sure we were totally, you know, he answered the questions correctly, but I mean, as a lawyer, he knows what the magic words are.
Any more questions?
Thank you.
May I ask one quick question for you?
Yes, sir.
Am I correct in my reading that the first and only time, or the first time I should say, that the allegation of negligent training was even broached or brought up was when it was included in the supplemental and amended pretrial questionnaire that was filed?
Yes, it was,
As part of the breach of the fiduciary duty claim.
at that point, and Judge King, in his wisdom, at the jury conference, was trying to sort things out based upon the evidence that had been presented.
Well, I was
And
thinking I read that like roughly a month or so prior to the
Right.
trial, there was an amended and supplemental pretrial questionnaire that you submitted.
Yes.
And it made reference to the negligent training as part of the breach of fiduciary duty claim.
Right.
Am I correct in that?
And Judge King believed that it was more appropriately part of the supervision.
Was that the first time that negligent training had been brought up in this case?
Yes.
Why was it not specifically pled? Now, you make reference to it being part of the
Fiduciary duty.
yeah, and that there was this implied consent. Why was it never explicitly pled?
It was, they were all tied together. And that would, you know, that Judge King decided that, well, we had decided, but Judge King decided that it should be part of the negligent supervision instruction.
Okay. All right, thank you.
So we believe that they certainly had notice of what it was, although they presented no argument at the end of the trial when the motion for judgment as a matter of law was presented. No argument was made as to negligent training by TCK against it, but it was brought up during the argument by Mrs. Parsons' attorney.
So really, we're parsing we're labeling whether something was an act that constituted negligence,
Yes.
or whether it's the name of the cause of action.
Yes. Yes, I agree.
Thank you. Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.